Diane Mercer laughed before the clerk had even finished calling our case. "You actually came alone?" she said, loud enough for the row behind her to hear. I guess no serious lawyer wanted this one. Her son Mark smiled at the table beside her. Their attorney did not. Graham Cole had been arranging a stack of exhibits when he looked down at the caption, then back at me. His hand stopped on the top page. "Rachel Mercer?" I nodded. He studied my face for another second. "Rachel Mercer from Talbot?" Diane's smile did not disappear all at once. It weakened first, as if she had missed a step in the dark. Graham removed his glasses. "We were on opposite sides of that appeal," he said. That was a long time ago. It was the only answer I gave him. Diane leaned toward Mark. "What is he talking about?" Graham did not answer her. He turned instead to the exhibit binder she had given him that morning and flipped back 3 pages. That caught my attention more than the recognition did. People think the dangerous moment in a courtroom is when somebody raises their voice. In my experience, it is usually when a careful lawyer goes quiet and reads something twice. 10 weeks earlier, Diane had filed a petition asking the court to remove me as trustee of the fund my husband Ethan left for our daughter, Lily. She claimed I had mixed grief with money, used trust assets for myself, and cut Ethan's family out whenever they questioned me. Some of that story sounded believable because some of it was true. I had pulled away after Ethan died. I had stopped answering Diane for a while. And one night, after midnight, I sat at the kitchen table with my jaw tight and my eyes burning and wrote a sentence in an email that looked terrible when printed by itself. Diane had printed it by itself. What she did not know was that I had spent most of my adult life reading records for the things people left out. And I had not come to court to prove I could represent myself. I had come to keep my daughter's future from becoming somebody else's emergency fund. The silver cross pen in my hand had belonged to Ethan. He bought it outside Fort Bragg after our 10th anniversary because, in his words, every lawyer should own at least one pen expensive enough to make losing it feel personal. The clip had a shallow scratch where he once dropped it in our driveway. I could have replaced it years ago. I never did. 14 months before that hearing, Ethan had used the same pen to sign the final version of Lily's trust. By then, cancer had taken most of his strength. He had always been broad-shouldered, the kind of man who could carry 2 grocery bags in each hand because making a second trip offended him on principle. Near the end, signing 6 pages tired him enough that he had to stop halfway through and rest. I reached for the documents. "We can finish tomorrow." He shook his head. That was Ethan, not dramatic. Just certain. The trust was not enormous. It held part of his life insurance, an investment account, and a mountain cabin his father had bought years earlier outside Boone. Ethan wanted the money protected until Lily was old enough to understand what money could do to people. He named me trustee. Diane was listed as successor trustee if I died, became incapacitated, or was removed by a court. Diane was good to us during Ethan's illness. That matters, because I do not want to rewrite her into someone she was not. She sat with him during chemotherapy when I had client calls. She brought Lily dinner on nights when the smell of food made Ethan sick. Once, at 2 in the morning, she drove 40 minutes because Lily had called her crying, and I had been awake long enough to read the same message 3 times without making sense of it. Grief did not erase those things, but it changed the weight of them. After Ethan died, Diane began talking about the trust in ways she never had while he was alive. I answered what I could and told her what was private. Then the questions became suggestions. Mark's company had taken a bad hit after 2 commercial projects stalled. Materials costs had climbed. 1 client delayed payment. Another went bankrupt. Diane said Mark only needed breathing room. 1 short-term loan, she told me, over coffee, secured. Documented. He'll pay it back. I said no, not because I disliked Mark. Because Ethan had written the trust for Lily, not for whichever adult in the family needed cash first. Diane stared into her cup. Ethan helped his brother. He did. He would help him now. Maybe. She looked up. Then why won't you? My shoulders settled. 21 years in uniform had taught me what came next. Do not explain more than necessary. Do not argue with emotion. Let the facts stand. So I said, because the trust does not allow me to make that decision based on what Ethan might have wanted. Legally, it was a good answer. As a daughter-in-law, it was gasoline. 2 weeks later, Mark stopped returning my calls. A month after that, Diane began asking Lily whether I had told her how much money was in the trust. I did not. I told myself Diane was grieving. I told myself Mark was embarrassed. I told myself that if I stayed calm long enough, the family would settle back into something recognizable. That was my mistake. Silence works well in court because the record keeps moving without you. Families are different. In a family, silence leaves empty space. And somebody always fills it. By late spring, Diane had decided I was controlling. By summer, I was secretive. By early fall, according to relatives I barely spoke to, I had become the woman who was sitting on Ethan's money while his brother's business struggled. Not even Mark. The last time I saw him before the petition was filed, his phone buzzed 3 times during dinner. Each time he turned it face down. "You need to get that?" No, his answer came too quickly. Diane watched him from across the table. Then she looked at me. A week later, she asked me about the cabin. Not what it was worth, not whether Lily loved it, whether the trust could sell it. I told her it could under the right circumstances. She nodded once. I remember that nod now. At the time, I let it pass. 10 weeks later, a process server stood on my porch holding a petition that said I had mismanaged the trust, isolated Lily from Ethan's family, and allowed grief to impair my judgment. I read the first allegation twice. At the second, I set the petition down and rubbed the bridge of my nose. At the third, my hand stopped on the page, because grief had impaired my judgment in one very specific way. It had convinced me that avoiding conflict was the same thing as protecting my daughter. By the time I understood the difference, Diane was asking a judge to remove me from the one responsibility Ethan had chosen me to carry after he was gone. 3 nights before the hearing, Lily went to bed and I stayed at the kitchen table with my laptop open, cold coffee beside Ethan's pen. The house had gone quiet enough that I could hear the refrigerator cycle on. I built a chronology from source records, not summaries. The quarterly accounting, the engineer's inspection. The contractor estimates, the certified delivery record. Mark's financing proposal, the trust instrument, the source export of Diane's email thread. By 1 in the morning, the hearing binder held 184 pages. One exhibit mattered more than its size. Diane's printout ended with my sentence about keeping her away from Lily. The source export did not. Earlier messages showed what she had told Lily about the cabin repair, and the line below mine showed the restriction was temporary and tied to counseling. The paper she had printed was authentic. It was simply incomplete. I placed the complete thread behind her printout and wrote 4 words on my legal pad. Ask for source copies. I still did not know what Mark had left out of his financing proposal. I only knew one omission had already become a pattern worth testing. The judge entered 10 minutes after Graham recognized me. By then Diane had stopped smiling. She did not lower her voice or pull back. She tapped one fingernail against counsel table while Graham spoke. Caution would have been easier to work with. This was impatience. While the clerk reviewed appearances, Graham leaned toward her and spoke quietly. I could not hear every word, but I caught enough. She is licensed. A pause. No, that does not mean she automatically wins anything. Another pause. Yes, I still represent you. I looked down so Diane would not see me smile. Whatever she had imagined would happen after Graham recognized my name, it clearly had not included her own attorney having to explain that recognition was not surrender. The judge turned to me. Miss Mercer, you are appearing pro se? Yes, Your Honor. You understand that the court will hold you to the same rules of evidence and procedure that apply to counsel? I do. He looked at the file. You are an attorney? Civilian appellate attorney, retired Army Reserve Lieutenant Colonel. Still licensed in North Carolina. That answers my next question. Nothing in his tone changed. No special treatment. No admiration. Exactly as it should have been. Graham stood for the petitioners. He was good. That became obvious within the first 3 minutes. He did not call me unstable. He did not dramatize Ethan's death. He did not repeat Diane's more emotional accusations. He narrowed the case. This is not a trial about whether Ms. Mercer loved her husband or whether she loves her daughter, he said. It is about whether continued unilateral control of a significant trust remains in the beneficiary's best interest. That was a much stronger argument than anything Diane had said outside court. He continued. The petition would show, he said, that I had restricted family access, made expenditures Diane could not reconcile, refused reasonable requests for information, and allowed personal conflict to influence trust decisions. Then he said something very deliberate. The petitioners are not asking the court to punish Ms. Mercer. They are asking for neutral oversight. Smart. Very smart. If Diane had stood up and said she wanted control, she would have sounded exactly like what she was. Graham made removal sound like moderation. When he sat down, the judge looked at me. Response: I stood. The trust has been independently accounted for. No funds are missing. No distributions were made for my personal benefit. The rest is better addressed through evidence. That is all? For now. The Graham did too, not agreement. Recognition. During the first recess, he found me near the water fountain outside the courtroom. Diane and Mark had gone downstairs with one of Graham's associates. For a moment, neither of us said anything. Then Graham gave a small laugh. I knew the name before I knew the face. I changed my hair. You changed more than that, so did you. He touched the gray near his temple. Fair. 17 years earlier, Graham had been a young assistant attorney general. I was a civilian appellate lawyer and an Army Reserve financial management officer. The case involved a state procurement manager fired after an internal investigation. One page in the administrative record did not match the agency's summary. An interview memorandum carried a finalization date after the decision letter claimed it had already been reviewed. The timing mattered. Graham had inherited the appeal late and relied on the summary prepared before he arrived. I had read the source record, every page. That was why Graham remembered me. He remembered the uncomfortable lesson. Never trust a summary when the source still exists. He crossed his arms. You still read everything? When somebody asks a judge to take something away from my daughter. I studied him. Did Diane give you the complete trust accounting? She gave us records responsive to our requests. That was not the same answer. He knew I heard the difference. I let the silence sit. Finally, Graham said, Rachel, I am not going to discuss my client's communications with you. I didn't ask you to. No, you asked a better question. The courtroom door opened behind us. Before he turned away, I said, one thing. He stopped. Ask for source copies. When we returned to the courtroom, Graham spoke to his associate before taking his seat. I watched the young lawyer open a laptop and begin searching through their digital file. Across the aisle, Diane noticed. She leaned toward Graham. He raised one finger without looking at her. Wait. And I realized something I should have understood weeks earlier. The hardest part of this case was never going to be proving that I knew the law. It was proving that the story Diane had built from real pieces became false, only when you could finally see the pieces she had chosen to leave out. Diane took the stand just before noon. Graham began gently. Mrs. Mercer, are you asking the court to take money away from your granddaughter? No. Are you asking to receive any trust assets personally? No. What are you asking for? I want the trust protected. She rarely lied when a carefully selected truth could do more work. Rachel stopped answering. Rachel became defensive about finances. Rachel refused to let family members see trust records. Also true, depending on what someone meant by see. Diane had asked me twice to send full account statements to Mark. I refused because Mark was not a beneficiary trustee, accountant, or legal representative of the trust. Instead, I sent Diane annual summaries and told her the trust's CPA could answer questions related to administration. Graham displayed one of my emails on the courtroom monitor. I am not distributing Lily's financial records through the family. That is how she spoke to us. Graham moved to the trust accounting. He showed a transaction for just over $32,000 from the trust account 7 months after Ethan died. Did Miss Mercer explain this expenditure to you at the time? Did you ask? Yes, and what were you told? That it was authorized. Graham paused. Were you shown an invoice? Not then. The silver pen turned once between my fingers. For now, it looked exactly the way Diane wanted it to look. Close enough to Ethan's death to look wrong. Graham moved on. Did you later learn Ms. Mercer had restricted your access to Lily? Were you told why? Not in any meaningful way. She had not been given every detail because the reason involved Lily's counseling. Diane looked at me. I lost my son, then I started losing my granddaughter. Pain and manipulation are not opposites. Did you ever believe Miss Mercer was stealing from the trust? Diane hesitated. No. Then what concerned you? Control. Everything had to go through Rachel. Information, visits, money, decisions. If we questioned something, we were treated like outsiders. Control. It was a smarter accusation because it did not require Diane to prove I had committed a crime. She only needed to make unilateral authority look dangerous. Diane said that cabin has been in our family for almost 30 years. Graham asked, who owns it now, the trust, and who controls whether it is sold? Rachel, the trust instrument controls whether it can be sold, Your Honor. Not me personally, who currently has authority to execute a sale on behalf of the trust. Rachel. Then he showed an email where I had written that I would not consider selling the cabin for family liquidity. Diane explained that Mark's company had been struggling, and that a temporary loan could have protected jobs. How many employees? Graham asked. 6 full-time. More during contract periods. And did you believe Ethan would have wanted to help his brother? Yes. Did Miss Mercer agree? No. By the time Diane stepped down, the story in the courtroom had changed. I was no longer the widow being mocked for coming without counsel. I was a lawyer controlling a trust, refusing to share records with relatives, blocking a loan that might save 6 jobs, restricting a grandmother's access to her granddaughter, and sitting on a $32,000 transaction I had not personally explained to Diane. Mark took the stand next. Graham asked about the company. Mark explained that he had spent 12 years building Mercer commercial contracting. Mark had borrowed against equipment to cover payroll and materials. How much did you ask Rachel to lend from the trust? Graham asked. $300,000. Was it intended as a gift? No. Would it have been documented? Yes. Secured. Yes. Did Rachel review the proposal? She said the trust wasn't there to rescue my company. Graham asked, how did that make you feel? Mark looked at me for the first time. Like my brother had died and suddenly I didn't count as family anymore. Graham handed Mark a copy of another document. It was a financing proposal Mark had emailed me months earlier. Where are attachments? Before I could think further, Mark's phone vibrated in the pocket of his jacket. Please make sure that is silenced. Yes, Your Honor. Final notice. Mark turned the phone face down on the witness ledge. And suddenly the question was no longer whether his business needed money. The question was how badly. After lunch, Graham did something I respected. He changed direction. A weaker lawyer might have kept pushing the idea that I was hiding money. The accounting was too clean for that to last forever, and he knew it. He called Diane back to the stand and handed her a printed email. Graham asked, do you recognize this? Yes. Who sent it? Rachel. When? About 3 months ago. What happened before you received it? Diane took a breath. I had spoken with Lily. About what? Her father, the trust. Things she was old enough to understand. Then what did Miss Mercer write? Diane read the sentence aloud. I don't want your mother anywhere near Lily right now. The courtroom became very quiet. He handed me a copy. It was authentic. I turned the silver cross pen once between my fingers. For a second, I could see Ethan using it at our kitchen table, pausing between signatures because his hand had started to shake. I put the pen down. Graham looked at the judge. This is the concern, Your Honor. Not theft, not missing money. A trustee who has allowed family conflict to affect access, information, and decision-making. Then he looked at me. Any objection to authenticity? No. Diane turned slightly. Diane's shoulders dropped half an inch. Not a smile. She finally had something I could not explain away with accounting records. Miss Mercer, is there additional context? Yes, Your Honor. Do you have it? I do, counsel. Graham stood. My client provided this email as part of a printed exchange. We are verifying whether additional messages exist. I noticed because I had spent too many years watching people when the question changed from what they expected to what they feared. The judge returned his attention to me. Miss Mercer, if there is more context, you will have the opportunity to present it. But I want to be clear. A trustee using a beneficiary's family relationships as leverage would concern this court. I understand. Did you restrict Mrs. Mercer's contact with Lily? Yes, the judge asked for how long? 3 weeks. Was there a court order? No. A medical recommendation? I hesitated. That hesitation cost me, Miss Mercer. There was a recommendation from Lily's counselor that we reduce conflict around her while she was experiencing significant distress. Does that recommendation specifically say Mrs. Mercer should have no contact? No. Graham rose. Your Honor, this is precisely the problem. I looked at him. He continued. Miss Mercer made a unilateral family decision, then attached professional language to it afterward. The petitioners are not saying she had no reason to be concerned. They are saying she has difficulty separating concern from control. The fact that I still believed the decision was necessary did not make my process perfect. Anything further on that point? Instead, I said the thing that hurt my position and helped my credibility. I could have handled the communication better. Then he said that may be true. But the question before me is whether this was one poor communication decision or evidence of a broader pattern. Whether I was safe to trust with unchecked authority. Graham asked the court to consider temporary appointment of a co-trustee while the case continued. I stood. That would create unnecessary expense and interfere with an administration that has passed independent review. Graham answered, if the administration is sound, neutral oversight should not harm it. For the first time that day, I did not know which way he was leaning. The moment before a decision, when preparation has taken you as far as it can and the result belongs to someone else. The judge removed his glasses. I am not ruling on interim relief yet. I want the complete record. Graham nodded. So do we, Your Honor. Then the judge looked directly at me, and, Ms. Mercer, if the remaining evidence shows that personal conflict has materially influenced trust administration, your military experience and legal background will not insulate you from removal. I would not expect them to. Rank had never been my defense. The record was, are you losing? Teenagers have a gift for removing every useless word from a question. I don't know. Then she asked, was Grandma telling the truth about the email? Yes, you really told her not to come near me? For 3 weeks. Why? Instead, I said, because something happened that I should have talked to you about more clearly. And if I explain it now, I want to do it without using you to help me win a case. Finally, she whispered, everybody keeps saying they're protecting me. It's getting old. For the first time since Ethan died, I wondered whether Diane had found the one accusation that could survive even after I proved the rest wrong. Because I had made the mistake I was always accusing other people of making. I had decided that having a good reason meant I did not owe anyone a better explanation. When we returned to the courtroom, Graham's associate placed a new stack of pages beside him. Then he stopped, just stillness. He turned to Diane. Mrs. Mercer, he said quietly, where's the rest of this thread? Diane looked at Graham as if he had asked the question in the wrong language. What do you mean, the rest of the thread? This starts at 8:43 that evening. There are earlier messages. Diane glanced toward Mark. I printed what was relevant. I decide what is relevant once I have the source material. Your Honor, may we have 5 minutes? The source copy was already in my exhibits. 10 minutes later, we were back. Your Honor, Petitioner's Exhibit 14 is incomplete. The quoted message is authentic. However, the printed exhibit omits earlier messages in the same thread that are material to context. I ask that the exhibit be replaced with the complete chain. Was counsel aware of the omitted messages when the exhibit was offered? No, Your Honor. Was your client? That is a question the court may wish to address through testimony. The complete thread went onto the monitor. She had written that Lily was old enough to know I had spent more than $30,000 of her father's money without telling the family. That statement is false. The expenditure was for structural repairs to the Boone property after the retaining wall failed. The invoice and inspection report are in the quarterly trust records. You always have an explanation after the fact. You received the quarterly report 11 days ago. The expenditure is listed on page 6. Lily deserves to know what kind of person controls her future. I don't want your mother anywhere near Lily right now. But now there was another line below it. We will revisit contact after Lily's counselor, and I are satisfied she is no longer being put in the middle of disputes about the trust. Mrs. Mercer, had you received the quarterly trust report before you spoke with Lily? Yes. Did that report identify the $32,000 expenditure? I did not understand it. That was not my question. Yes. Did you tell Lily that her mother had spent the money on herself? I told her I was concerned. Again, that was not my question. I may have said something like that. Miss Mercer, you may proceed. I asked one question. When you told Lily I had used trust money for myself, had you already received a report stating the money was used for repairs to the cabin? Yes, no further questions. Instead, he asked permission to call the trust accountant out of order. Marisol Vega walked to the witness stand carrying a thin black folder and a mechanical pencil clipped to the front. She had handled fiduciary accounting for almost 20 years and had worked with the trust since Ethan created it. He once described her as a woman who could make a calculator feel underprepared. Ms. Vega, did you conduct an independent reconciliation of the Mercer Trust? Yes. Were funds missing? No. Were there unexplained transfers to Rachel Mercer? No. Any personal expenses paid for her benefit? No. He displayed the $32,000 transaction. What was this? Emergency stabilization and drainage work at the Boone property after partial failure of a retaining wall. Why was trust money used? The property belongs to the trust. Was the work necessary? Yes. An engineer documented risk to the foundation and access road. Was Miss Mercer paid any portion of those funds? No. Did she choose the contractor? She obtained 3 estimates. The lowest qualified bid was selected. Graham nodded. In your professional opinion, has Ms. Mercer administered the trust improperly? No, trustee's job is not to make every relative happy. It is to follow the instrument and document every dollar. Based on the records I reviewed, that is what Miss Mercer did. My grip on the pen eased. I drew a full breath for the first time in several minutes. Not victory, just room to breathe. Graham sat down. My questions are complete. I approached Marisol. Did I ever instruct you to hide information from Diane? No. Did I ever ask you to change the description of an expense? No. Did you send Diane the quarterly report containing the cabin repair? Yes. When? 11 days before the email exchange we just reviewed. Do you have proof of delivery? Yes. She opened the black folder. A certified electronic delivery record was already marked as an exhibit. Diane had opened the document the same afternoon it was sent. I heard Mark breathe out behind her. That detail mattered. Receiving a report could be dismissed. Opening it was harder. I asked, can you tell whether she read page 6? No. Fair answer. I nodded. So the record proves she received and opened the report. It does not prove what she read. Correct. Thank you. That distinction mattered too. I did not need Marisol to claim more than the evidence could carry. The judge looked toward Diane. Mrs. Mercer, the court is now faced with a different concern than the one presented this morning. Diane said nothing. You alleged that Ms. Mercer withheld financial information. The evidence shows that at least some of that information was provided before you represented the expenditure differently to the beneficiary. Diane swallowed. I was trying to protect my granddaughter. The judge's voice remained even. From what? Diane opened her mouth. Nothing came out. I looked away before the silence became cruel. Only for a second, then Mark's phone vibrated again. This time Graham heard it too. He turned. Mark silenced the phone immediately. Graham looked at him for a long second, then at his associate. She leaned over and whispered something. I caught only part of it. Loan documents. Graham's eyes moved to the financing proposal on his table. The one missing its attachments. Then he looked at Diane. Your Honor, before we proceed further, I need to review documents produced this morning concerning the proposed loan. Diane turned toward him. What documents? Graham did not answer her. The judge granted another short recess. As people began to stand, I stayed seated. The silver pen lay beside my legal pad. For most of the day, the case had been about whether I had hidden something. Now, for the first time, the question had moved across the aisle. Diane had received the financial report. She had presented Lily with a different version anyway. She had given her own lawyer part of an email thread. And Mark had given him part of a financing proposal. 1 omission can be carelessness, 2 can be habit. 3 starts to look like a method. I picked up Ethan's pen. The clip caught against my thumb where the old scratch had always been. Ethan had not left me that trust because he thought I would never make mistakes. I was beginning to understand that. He had left it to me because when the facts became uncomfortable, he trusted me not to look away. Across the courtroom, Graham was reading the missing loan attachments. Halfway through the first page he stopped, then he looked at Mark. This time he did not ask for the source copy, he already had it. And whatever was on those pages had just changed the case again. When court resumed, Graham did not look at me, he looked at Mark. Mr. Mercer, I need to ask you about the attachments to your financing proposal. Mark shifted in the witness chair. What attachments? Graham held up the packet, then he set it on the witness ledge. The paper hit the wood with a flat slap. For 1 second, all I could hear was the HVAC and the single click of Graham's pen. The lender schedule, the personal guarantee, the maturity notice. Mark's hand stopped moving. I touched Ethan's pen. Source copies. Diane whispered something from counsel table. Graham raised a hand. Please. She stopped. The first document showed that Mark's company did not simply need breathing room. It needed $286,000 within 63 days. If the bridge note was not paid, the lender could take several pieces of equipment Mark needed to keep his crews working. The second document was worse. Diane had signed as a limited guarantor. Part of the equity in her own home was exposed. That explained the questions. The urgency, the cabin. Graham asked Mark, "Did Rachel know your mother had guaranteed part of this debt?" "No, did you tell her no? Why not?" Mark looked at Diane. "She said it would complicate things." Graham was quiet for a moment. Then he asked, "Complicate what?" Mark did not answer. The judge looked at him. "You may answer." Mark rubbed both hands over his knees. "The loan from the trust." The courtroom went still again. Graham turned to his associate. She handed him another exhibit. I recognized it, not because I had seen it before. Because I had requested it. 6 weeks earlier, when Diane's petition accused me of unreasonably refusing a secured loan, I had asked for every document related to the proposal. What arrived that morning included an email chain between Diane and Mark. Graham read the first message silently, then he looked toward Diane. "Mrs. Mercer, I am going to ask that you return to the stand." She did, slower this time. Graham approached with the email. "Did you write this to your son?" Diane looked at it. "Yes, please read the highlighted sentence." She swallowed. "If Rachel is removed, the trust names me next. The Boone property can be converted without waiting another year." "Nobody moved," Graham continued. "What did you mean by converted?" "Sold. And what did you intend to do with the proceeds?" Diane's voice became smaller. "Not all of them. That was not my question." She closed her eyes. "Make the loan." There it was. No hidden confession, no criminal mastermind plan. Just a sentence written by a mother whose own home was exposed to her son's debt, and who had slowly convinced herself that somebody else's money could solve his emergency, because the people involved shared a last name. Graham placed the email down. "When did you write this?" 3 weeks before we filed. That mattered. The petition had not created the idea. The idea had existed first. I looked at Mark. His phone was finally silent. Graham asked one more question. "Did Miss Mercer ever agree that sale of the cabin for the purpose of funding your company was in Lily's interest?" "No." "Did she refuse?" "Yes." Graham returned to his table. For the first time all day, Graham rubbed once at the bridge of his nose before returning to his table. "Your Honor, the petitioners maintained their request for appropriate oversight. However, in light of the complete record, we are no longer asserting that Miss Mercer concealed the cabin expenditure or failed to provide the financial report at issue." Diane turned toward him. "You're giving up." Graham did not raise his voice. "No, I am correcting the record." That was the sharpest sentence spoken in the courtroom all day. The judge looked at me. "Miss Mercer?" I stood. "I have a few questions for Mrs. Mercer." Diane watched me approach. Her jaw tightened. Her eyes stayed on me instead of the email. Looking at me was easier than looking at the sentence she had written. I stopped several feet from the witness stand. "You wanted Mark's company to survive." "Yes." "You believed Ethan would have helped him." "Yes." "You were personally exposed if Mark defaulted." She hesitated. "Yes." "You did not tell me that." "No." "You asked whether the cabin could be sold." "Yes." "Before filing this case, you obtained an estimated market value for it." Graham looked down at his notes. Diane stared at me. Yes, that estimate had also appeared in Discovery. She had asked a former colleague from her real estate days to prepare a market analysis. "Approximately how much?" $620,000. "And before this petition was filed, you wrote that if I were removed, you expected to become trustee, sell the cabin, and make a loan to Mark." Her jaw tightened. "I expected him to repay it. I believe you." The answer surprised her. I continued. "You did not plan to steal the money." "No, you planned to use Lily's trust to solve a family crisis." "Yes, because you believed family should help family." "Yes." I paused, even when the trust did not belong to the family. Diane looked at me. For the first time, she had no prepared answer. I did not ask another question. I returned to my table. That was the part people misunderstand about cross-examination. Sometimes the purpose is not to make someone look evil. Sometimes it is to make the decision visible. Diane had made one. She had decided that Mark's emergency mattered more than the boundary Ethan had placed around Lily's future. The judge called a short recess before closing arguments. I went to the hallway. Lily stood near the window. She did not ask whether I was winning this time. She asked, was Grandma going to sell the cabin? She wanted to. For Uncle Mark? Yes. Lily stared through the glass. That was Dad's favorite place. I know. Would you ever sell it? If keeping it stopped being good for the trust, yes. She turned toward me, her lips pressed together before she looked back through the glass. So you're not promising to keep it forever? No. Then what's different? I thought about it. The difference is that if I ever sell it, the reason has to be about you. Not me, not Grandma, not Uncle Mark, Lily nodded slowly. Okay, then she went back inside. I stayed there another 30 seconds. Long enough to understand that protecting something did not always mean preserving it exactly as it was. Sometimes it meant refusing to let the wrong person decide why it should change. Back in court, Graham kept his closing short. He said Diane's concerns had not been invented from nothing. There had been poor communication. There had been family estrangement. I had restricted contact. Those facts remained. But he also acknowledged that the financial administration had been independently verified and that the complete record undermined several factual claims supporting removal. It was a professional argument, not a rescue attempt. When my turn came, I carried no notes to the podium. Your Honor, I made mistakes after my husband died. Diane looked at me. I became harder to reach. I confused privacy with communication. And when I became angry about what was said to Lily, I wrote an email that was more absolute than it needed to be. I let that stand, but none of those mistakes changed the purpose of the trust. I looked at the exhibits. The money is accounted for. The disputed expense-protected trust property, the reports were delivered. And the proposed transaction I refused would have shifted trust assets toward a family member whose business debt was approaching default. Another breath. I do not believe Diane wanted to steal from Lily. That made Diane look up. I believe she became convinced that saving Mark was the same thing as honoring Ethan. I looked at the judge. They are not the same thing. That was all. The judge reviewed his notes for several minutes. Then he began. The court does not require a trustee to be a perfect communicator. He looked at me. Nor does legal experience excuse poor judgment in family matters. Fair. Then he looked toward Diane and Mark. But removal of a trustee requires more than disagreement, hurt feelings, or the belief that another family member would make different choices. He reviewed the accounting. No misappropriation, no self-dealing. No undocumented personal benefit. The cabin repair had been necessary and properly recorded. The report had been delivered. The court also found that the incomplete email presentation had created a materially misleading impression of the contact restriction. Then he reached the proposed loan. The evidence shows that the petition to remove Miss Mercer was filed after she refused a transaction that would have benefited Mr. Mercer and reduced financial exposure borne in part by Mrs. Mercer. Diane lowered her eyes. The court does not find that motive criminal. A pause. It does find it conflicted. My fingers closed around Ethan's pen. The petition to remove Rachel Mercer as trustee is denied. Nobody gasped, nobody applauded. Real courtrooms are usually quieter than stories make them. The judge continued. The request for temporary co-trustee oversight is also denied. Independent accounting has already provided adequate financial review. I exhaled slowly. The judge was not finished. Mercer, the court strongly encourages clearer communication concerning matters affecting the beneficiary. Your right to administer this trust does not make silence a virtue. That one landed exactly where it needed to. Yes, Your Honor. Then he looked at Diane. And Mrs. Mercer, concern for family does not create authority over property that belongs to someone else. Diane nodded without looking up. The ruling ended there. 4 days later, the written order denying the petition to remove trustee and the request for temporary co-trustee oversight was entered. No trust asset was transferred to Mark. The proposed $300,000 loan never left Lily's trust. And the Boone cabin, valued in Diane's own market analysis at approximately $620,000, remained trust property. Mark's $286,000 bridge obligation remained his company's debt, not Lily's. No speech about my military career, no reference to rank. No reward for having once worn a uniform. Graham recognized my name that morning. The judge did not care. By late afternoon, neither did I. The thing that saved Lily's trust was not who I had been 17 years earlier. It was what the record showed that day. As the clerk collected the exhibits, Graham walked past my table. He stopped beside me. Source copies, he said. I looked at him. Every time, he gave the smallest nod, then he went to speak with his client. Diane remained seated. Mark stood beside her. For the first time since Ethan died, they were not looking at me to solve what came next. And I realized the court had given me exactly what I asked for. It had protected the trust. What it could not give back was the family we had before anyone decided that love entitled them to cross a boundary. Diane caught up with me in the courthouse lobby. Rachel. Lily stopped beside me. Mark was still upstairs with Graham, probably trying to figure out what $286,000 looked like when it could no longer come from us. Diane held her purse with both hands. I need to explain. I almost told her she had explained enough. Instead, I waited. I was scared, she said. Mark could lose everything. I know, he has employees. Families depend on him. I know that too. Her eyes moved toward Lily. I thought Ethan would have helped. Maybe he would have. That was the dangerous part. Dead people are easy to recruit into arguments because they cannot correct anyone. I said, Ethan might have helped Mark with his own money. Diane looked at me. He did not leave you his money. He left Lily a trust. Her face tightened. I wasn't trying to hurt her. Lily spoke before I could, but you told me Mom took Dad's money. Diane went still. I was angry. You knew what the report said. Diane looked at me, as if I might soften the question for her. I did not, finally, she said. I knew what Rachel said it meant. That isn't the same thing, Lily answered, 16 years old. No military training, no law degree, still the clearest sentence spoken all afternoon. Diane wiped beneath one eye. Can I call you Lily? Thought about it. Not about the trust, Diane nodded quickly. And don't ask me questions about Mom through me. Another nod. Okay, Lily looked at me. She was not asking permission. She was checking whether I would respect her answer. I did. That sounds fair. There was no hug, no apology that repaired 14 months in a marble hallway. Diane walked out one set of doors. Lily and I used another. No one called after the other. That was honest. Mark's company did not collapse the next morning, and it did not magically recover. He sold 2 pieces of equipment, renegotiated part of the bridge note, and reduced his crew for a while. 3 months later, he called me. Not for money. He said I should have told you how bad it was. Yes, I was embarrassed, I know. A pause. Then I said something I should have said much earlier. Being embarrassed doesn't make you dishonest, Mark. Letting other people make decisions without the full facts does. He was quiet. Fair enough, we did not become close again. But we stopped pretending silence was a relationship. Diane started seeing Lily for lunch twice a month. At first, Lily came home from those lunches closing cabinet doors harder than necessary. Then she stopped doing that. Trust did not return because the judge ordered it to. It returned in smaller things. A birthday card with no question about money. A soccer game where Diane did not mention the case. One dinner where everyone managed to talk about Ethan without using his memory to win an argument. That was progress, not forgiveness. Progress. Almost 6 months after the hearing, Lily sat across from me at the kitchen table filling out forms for her first college visits. She reached for a pen. The silver cross pen was beside my coffee. Can I use Dad's? For years, my first instinct would have been no. Too valuable, too easy to lose, too connected to one afternoon when Ethan's hand had trembled while he signed his name. I picked it up, then I placed it in front of her. Sure. Lily smiled and started writing. The scratched clip caught the kitchen light. For the first time, I did not see Ethan signing something because he was preparing to leave us. I saw our daughter writing down where she might go next. I spent 21 years believing discipline meant knowing when not to speak. Sometimes it does, but families taught me something the army never could. Silence does not stay empty. If you leave important things unsaid long enough, fear, pride, and resentment will eventually speak in your place. I still value privacy. I still do not explain myself simply because someone demands it. But I no longer confuse dignity with disappearing. Diane thought winning meant getting control of the trust. For a while I thought winning meant keeping it. We were both wrong. The real victory was making sure Lily grew up knowing that love can ask for help, love can disagree, and love can even forgive. What love cannot do is claim ownership over someone else's future. Ethan's pen stayed on Lily's desk after that night. I never asked for it back. Some things are worth protecting because they belong to the past. Others are worth letting go because they finally have somewhere new to go. And if there was one thing that courtroom taught me, it was this. The truth does not always need a louder voice, but it does need someone willing to give it the whole record. If this story stayed with you, tell me what boundary you learned to protect when someone else tried to define your intentions for you. And if quiet strength, family pressure, and the facts people leave out are the kinds of stories you value, stay with me. There are more ahead, because there is another part of this that took me longer to understand. A boundary is not punishment, it is not revenge, it is the line that keeps love from turning into ownership. Family conflicts often begin with partial truths, A sentence without the message above it. A request without the debt behind it. A promise about what someone who is gone would have wanted. Each piece can be true and still build a false story. If you have ever been expected to explain yourself over and over, you know how tempting it is to stop talking. If you have ever been the one asking for answers, you know how quickly silence can look like guilt. And if two people you love have both insisted they were protecting you, you know what it is like to become the territory they are fighting over. You are allowed to say no to a request that would make you betray a responsibility you accepted. You are allowed to protect money, property, privacy, time, or peace that is not yours to give away. You are allowed to ask for source copies before accepting somebody else's version of events. And you are allowed to admit that you handled part of a conflict badly without surrendering the part where you were right. That is what dignity looks like to me now. Dignity is holding the complete record, including the pages that are uncomfortable for you, and still choosing principle over pride. Read the whole thread, open the attachment, check the date. Ask what was left out, then make the decision you can still defend when the room gets quiet. If someone you know is trying to hold a necessary boundary without losing their dignity, share this story with them. They may need the reminder that saying no is not the same as abandoning someone. Diane laughed because I represented myself. Graham recognized my name. Neither of those things won the case, the whole record did.